Good morning, everyone. I'm Fumi Mitsushi, Vice Chair of ZSFG. I have the honor to introduce our distinguished visiting lecturer today. The Honorable Garrett L. Wong is a retired judge of the Superior Court of California, County of San Francisco, where he served for more than 20 years. He's a San Francisco native and has held multiple court leadership roles, including presiding judge, assistant presiding judge, and supervising judge of the criminal division, and serving in the civil division handling complex civil matters. Judge Wong has overseen the court's appellate panel and presided over significant asbestos and California Environmental Quality Act litigation, including a landmark decision facilitating construction of the Chase Center. He played a central leadership role during the COVID-19 pandemic, establishing policies that kept the court operational while promoting access to justice. A major focus of his career has been behavioral and mental health law. Judge Wong helped develop behavioral and mental health courts, authored widely used guidance on mental health proceedings, and has served on statewide judicial committees addressing cases involving individuals with mental illness. He has also worked closely with UCSF's Forensic Psychiatry program and the Forensic Mental Health Association of California on courtroom training. Before joining the bench, Judge Wong practiced as a telecommunications attorney, private litigator, and San Francisco deputy public defender. He is a graduate of UC Berkeley, the University of Pennsylvania Law School, and Georgetown University Law Center. Please join me in welcoming Judge Garrett Wong for his distinguished visiting lecturer talk today, entitled Mental Health Evaluations and Testimony and Their Role in the Courtroom.
Thank you for inviting me to be a part of the UCSF Department of Psychiatry and Behavioral Science Distinguished Lecture Grand Round Series. And I want to do a shout out to Dr. Renee Bender and Dr. John Chamberlain, who I think are responsible for this engagement, and I thank them for the opportunity to speak with you. I know them from having worked with them and presiding over moot court sessions involving their forensic psychiatry fellows for the past 15 years. And I want to say last fall, your Office of Continuing Education asked me to prepare a syllabus for you, but since then I've thought it might be more practical to step beyond rudimentary law and procedure, which I might say is kind of boring, and to talk to you about giving testimony in the courtroom. So before I do so, let me turn to the usual or customary caveats. On the 1st of this year, I became a retired judge, which means I am no longer an active member on the bench. Next, the opinions and remarks by me are mine alone and are not of the San Francisco Superior Court or of any other court which I might reference in this presentation. Next, this is a very high-level presentation. I'm unable to condense my observations into, say, 45 minutes. And last, I will set aside time for questions because I think most of you want to ask me how to handle things. But let me just tell you that I cannot give you any legal advice, nor can I tell you how I would have ruled on any particular case or set of facts. Okay. So the assembly here today reminds me of when I get jurors into the jury assembly room or in the courtroom. You're being required to appear at a hearing or trial by notice or subpoena, and that ruins just about anyone's day. And I think it's perfectly normal to experience doom, gloom, and so forth. You're literally parachuted into the courtroom having any idea about what is expected, sat down in front of strangers, and then interrogated by lawyers who make you feel horribly incompetent. So that's a juror's experience, and that is what I found to be common for any witness who is testifying in court. So how do you cope with that ordeal? Now, Dr. Cynthia He, who you may know, offered that many of you want me to talk about how to, regardless of a specific legal issue. One, give good testimony in court. Two, prepare effectively with the attorney who is offering your testimony. And three, how not to be fazed by opposing counsel. And I might even extend that to the lawyer who has put you on the witness stand. So I'm here to give you one judge's insight on your place in the scheme of things. Let me make this observation. The principles are universal, and I want to assure you, you got this. You really do. And what I'm going to do this morning is try to give you some context so you understand that the things that you do every day are exactly what we want to hear in the courtroom. Okay? So, right up front, I'm going to give you the three basic rules that address the concerns raised by you and described by Dr. He. And that is this. One, listen to the questions posed by the examiners. Two, answer the question, only the question. And three, do not volunteer any information. That's basically it. That applies to anyone. And you might say, well, gee, that's really simple, but that's what we want you to do. I've been doing this as a judge for 20 plus years. And before that, I was a trial lawyer. And that's all we asked of a witness. So if you know your work and you follow these rules, you'll be able to work through any courtroom experience. Now, I've heard many people voice concern about the adequacy of the risk guidelines. And, I recommend, the guidelines, which I have right here, which I put out in plastic, and I'm going to pull up because I want to assure you that I've looked at them, is that the guidelines talk about, I think this is it here. These are things that you may recognize. I don't know if you've seen them, but they are directed for your role in a civil deposition and a civil trial. And I've reviewed them, and I understand why they cannot be, especially applicable to you if you are about to engage in testimony for an LPS proceeding, a Reese hearing, or even a competency proceeding where you're serving as a fact witness, just because you happen to be working with another patient when the criminal defendant who you are testifying in the case was rolled into ER with a gunshot wound. I mean, I don't think that these guidelines serve you or help you other than to provide some universal principles. It's not to say that the guidelines don't work for you. It's just that, again, you need to understand that the three basic rules that I've given you also apply there. Okay? So I do recognize that civil depositions are procedurally different, but again, I want to emphasize that the guidelines actually offer the same suggestions that I will discuss this morning. Risk management has also marked the guidelines confidential and privilege, and that's in quotes. So I'll honor that request. I'm not going to be speaking directly to specific language but I will ensure or assure the risk management folks that I'm not going to be talking about specifics that are contained in their guidance. Okay, so there are going to be 6 topics to cover. Some are very short that I have, and others are going to be a little longer. And I want to leave enough time for you to ask questions, and hopefully I can respond to them and make you feel assured when you come out here that you be able to at least appreciate what you should be thinking about. So the 6 topics are: 1, your task as a witness before the trial, the trier of fact. And I want to emphasize that the trier of fact is defined as either the judge or the jury. They are the folks that are going to be making factual determinations and even making judgments about how to make a decision in a case. So that's 1. 2, the box. And I'll explain that momentarily. 3, how to be a good witness. 4, direct examination. 5, cross-examination. And 6, the judge's role as a gatekeeper and common evidentiary objections. And I think some of you are saying, I heard some number, 352, or what's a Sanchez objection? And some of you have heard that, or maybe you've heard the word hearsay. And I'm going to try and explain all of that. That's, if anything, it's very disconcerting for any of you not to know what that means, and to hear a judge say to the lawyer, either rephrase the question or the objection is sustained, and you have no idea what that's about. So let me get to that. So first thing, your task as a witness. And this applies to whether you are working in citywide and you've been called to testify about a client, or you're working in ER, or you are testifying as an expert witness in a malpractice suit where there's an issue about whether another clinician has breached the standard of care. Okay, it applies all the same. Your specific role or task as a witness is to give information to the trier of fact, that is the judge or the jury, to make a decision. And let me emphasize, you are not expected to be an advocate. In fact, you are not an advocate. You're not there to give an ultimate legal determination. You're only there because you are a part of the story that the lawyer is telling. Think about some of the lawyer commercials or advertisements you hear. Just think about it. I was thinking about it over the weekend, and up pops one of the commercials on television. The basic approach of each one of these advertisements is the lawyer is going to tell a potential client their story. They're promising to tell that potential client's story to the court and to advocate for a just result before the trier of fact. Assuming the lawyer is hired, the lawyer investigates the case. You are discovered as a witness who can say something to help the case. And if you're called to be a witness, your testimony supports one or more aspects of the lawyer's case narrative. Okay, so they're telling the story. They're telling the client's story. Just think of it that way. Each lawyer, once they've perhaps interviewed or they've discovered you, they must plan the case, make a judgment about the presentation of evidence, and your testimony in a logical and linear fashion. Then they drive the case home with their arguments to a legal conclusion before the court. For any side in a case, a witness, and that's you, must remember that it is the lawyer who absolutely controls the narrative. So what I'm saying to you is you don't need to worry about advocating for the client or the position of the government or the mental health community organization. That's not your role. As a witness, you are part of the lawyer's narrative and a component of the lawyer's burden of proof. And you've heard that expression, but all that means is their obligation to show that something is true and correct. The burden is on a lawyer to show, sometimes by a preponderance of the evidence, or that something is clear and convincing. You've heard that often in the LPS world, or beyond a reasonable doubt. Okay, that's the burden of the lawyer. You may even know what I call the ask, but the justice system doesn't expect you to make the ultimate legal determination. All the court requires is that a witness give credible and believable testimony about something relevant to a deposition, hearing, or trial. Okay, so relax. For jurors, it's sort of the same, and I'm going to explain. And much of this, after 20 years, is, well, you won't be here for, doing this for 20 years in the courtroom, or maybe. But I want you to appreciate that it's not really in your hands. The only thing that we want you to do is to testify and give an accurate account, a believable account about what happened, what you saw. And I'm going to get to that in a moment. All right, you heard me identify the second area, which is what I called, that I'm going to talk about, and that's called the box. And I use that metaphor to explain what jurors have to do in a case. And I'm going to explain it, and then I will also, I thought about it this morning, link that into what the jurors and the judges are doing. Okay, so you won't find the box, the metaphor of a box in any legal treatise. In fact, most judges don't even know what that is themselves, but they do know that there is a universe of what jurors can consider. And I use the box to help potential jurors understand their responsibilities as a trier of fact. During juror selection, I tell prospective jurors to think about a box. Any box will do. I explain to them that their job is to evaluate any evidence that is admitted into the box, and then to decide the case based on the evidence and the applicable law, the relevant law. Okay, because many people come in, and I think you've had that experience. I don't know I don't know all these legal terms and so on and so forth. And I explain to them, you don't need to, because the court is going to explain much of the law to you. All you've got to do is evaluate what's in that box. Okay? Evaluation is not a measure of quantity. For example, who has the most witnesses? It's a matter of the quality of the evidence that's been admitted into this box. So that's the world that they've got to look at. And you are part of that world. Their job is to weigh what's in that box, to weigh the evidence, to see how the evidence fits within the scheme of things, and then apply the law. Okay. And at the beginning of the case, I explained that the box is empty. Some lawyers at the beginning of the selection process, they call it voir dire, Some people, like in Texas, pronounce it boy or dyer. But all that means is to see, to show. And it's just a question period when they want to see whether someone can be fair and impartial. So they ask this question, and you won't be, as a witness, you will never see this. You'll not even hear this concept of the box. They'll ask a trick question. If I were to have you give a verdict right now, what would it be? And the juror would stumble. And I tell them in advance, the answer is no verdict, because there's nothing in the box yet. There's no evidence. There's nothing. There's no testimony. Nothing. Okay. But I do remind them that the only thing that you get to consider as a juror is what's in that box. And that includes, to you, your testimony in the case. I then define evidence. Well, what goes in that box? And there's three basic things that go into the box. Oral witness testimony, that's you, or maybe sometimes it's a deposition transcript or it's some recording of someone's remarks, but it's witness testimony. Two, tangible evidence like documents or exhibits or demonstrative aids. Think contract, map, or photographs, or maybe it's a construction blueprints, that sort of thing. And three, which you never need, well, you may have to hear about, a stipulation where the lawyers agree that some fact is not in dispute for purposes of the hearing or trial. Stipulations are really done so that we don't waste time. And wasting time is a very big issue for judges. Okay, so also for jurors, because when the jurors come into the courtroom, they want to know, how long am I have to be here? And usually I say, well, for most of you, maybe a day or 2 days, because you got to deal with jury selection. But if the case is 2 weeks long, I tell them it's going to be 2 weeks long, and the lawyers are expected to finish the case in 2 weeks. We don't go beyond that. So for me and for the lawyers, and this is just an aside, the admission of evidence, the case itself, it's all about clock management. So that will become important as I discuss this first. Okay. The other thing I tell the jurors, and I want to emphasize, is that the jurors are asked to evaluate everything in the box and nothing beyond the box. This means they cannot do independent research, look to see whether there's someone in the gallery, and those are the folks behind the bar. For example, if some of you know who Oprah was, or Dr. Phil is sitting behind the bar in support, theoretically in support of the side that's in the courtroom, that's supposed to influence the jurors. Well, I tell them, no, you don't do that. And in the past, I've had gangbangers, a group of people, when I was doing the criminal courts, they'd sit in a courtroom, try to intimidate a witness. And I tell the jurors, no, you can't consider that. You just have to consider what's in the box, what's the evidence in the case. I tell jurors, you can't go do independent research, listen to YouTube commentary, do a documentary about, rely on a documentary to decide things. If they hear a clinician, maybe you outside the courtroom, they have to ignore it. Why? Because it's not fair to the parties in the case. Remarks can be taken out of context or misconstrued. You may be speaking about someone else. So, and this is important. And this is, again, something about witnesses themselves. I point out to the jurors, you consider what's in the courtroom, because what evidence is presented in that box in the courtroom can be tested, can be shown to be right or wrong by either side, or it can be questioned, and it can be contradicted by other evidence. Courts are public forums that depend on disclosure. in a courtroom of facts and evidence. And you'll kind of understand this when I define hearsay at the end of this. But we're really thinking about having the trier of fact consider only what's in the courtroom. Now, you might say, what's this have to do with you? The lawyer who has called you has made a decision that your evidence is evidence that goes into the box that supports his, her, or their narrative. If you can listen to the question, answer the question, and never volunteer, your job is done as a witness. As much as you feel compelled to do so, if no question is posed, it is not your role to volunteer anything on the witness stand. Okay? Don't volunteer, and I'll explain why shortly. All right. The next area that I'm going to talk of the 6 is number 3, and this is short. How to be a good witness. All right. You have to step away from the idea of viewing yourself as a good or bad witness. The only people who are concerned about whether you are a good witness are the people who have put you on to testify. Only the lawyers and the parties see it that way. If you support us, you're a good witness. If you support them, the opposing side, you're a bad witness. Okay? The question for the court and for the jury is whether you can give relevant, credible, and believable testimony. That's all we care about. I've been sitting up there for 20 years, and I'll say to myself, okay, is this person believable, credible? Are they putting on testimony that's tied to the case and is part of the narrative that the lawyer is trying to give the court? Okay. Number 4. So we're already there. Direct testimony. Direct testimony is the lawyer's opportunity to have a witness give facts to build the case for the judge or jury. And I think many of you are what you call fact witnesses. In the courts, we call them percipient witnesses, but it's all the same. As a fact witness, you're testing about what you personally observed, and that means what you heard, observed, sensed during a particular moment in time that are relevant to the facts and circumstances of the case. Now, to make it easy and comprehensible to a jury, the lawyer who does direct examination will ask short, open-ended questions that generally start with who, what, why, where, and when. And if you don't remember something, the lawyer may ask if there is something to refresh your recollection. Once presented to you, you may or may not recall, but a lawyer may be able to show that a particular detail is one of many that perhaps you handled during a particular shift. Let me just say, there was a Professor Irving Younger, who's long passed, who used to say a bowl of meatballs can refresh someone's recollection. So if a bowl of meat, and so bring the bowl of meatballs if that's what's going to refresh the recollection. It's not entered into evidence. It's simply to refresh the memory of a witness. Okay. The one prohibition that lawyers observe during direct examination, and again, that's the person or be the people who've called you, is what you've heard before, the leading question. And though you may have heard often an explanation about a leading question in the media, and what that is a question that calls for a yes or no answer. The correct definition of a leading question is one that suggests the desired answer to the witness. Since the witness who's been called by that lawyer is presumably friendly to that lawyer, the witness will probably follow the lead. This isn't an absolute, and there are exceptions to the norm. One notable exception is that judges will permit some leading questions on a preliminary matter, or when the witness becomes a hostile witness against the lawyer who called the witness. But for the most part, lawyers will try to avoid doing leading questions or having leading questions when they are putting you on as a witness. Okay, so let's move on to what happens when you are called to testify. And I want to do this, and I apologize to folks who've testified in court, but arrive early. If you have a moment before you are called, look at the courtroom beforehand. Courtrooms are open to the public. Usually, you will be asked to wait outside the courtroom. And it varies unless you're an expert witness. But I'm not here to talk about experts today. That could take another course. Okay, you'll be asked to step forward. Once you're in the courtroom, you'll be asked, or you'll be called outside the doors, and you're brought in to step forward into the witness box. Once you're in the witness box, you should remain standing and raise your right hand, and the clerk will remind you, you'll be sworn under oath to testify. You'll be asked your name and to spell it out loud for the record. The examination typically proceeds in this manner: direct examination by the lawyer who called you, cross-examination by the lawyer who's opposing the lawyer who called you, and redirect examination. Once in a while, there is recross-examination, but that's really up to the judge, because you could go on backwards forever and forwards forever. And so judges try to, again, be mindful of time and efficiency. So we'll have within our authority the ability, or our discretion, the ability to cut it off, because after you've gone back once, twice, and a third time, I think everybody gets the point. Okay, so there are variations to the order of examination depending on schedules and so forth. But if you follow my 3 rules, it doesn't matter. All right, so for the witness who's never testified before, I'll tell them the following. It's what I call the witness admonition or instruction. 1, please let each lawyer finish the question before you start answering, because you may be answering something that he or she or they are not asking. 2, please listen carefully to the question. For this audience, I'm meaning you and those who are live streaming, my suggestion is count to 3 in your head and then answer the question. This gives the jury time to absorb the question, and for you, the time to formulate your answer and perhaps to give the appearance of thinking deeply. Okay? Next, our process does not exceed by way of narrative. We ask for separate and discrete bits of information. If either lawyer wants more information, the lawyer will ask another question. When a witness engages in a conversation with the lawyer on the witness stand, I tell the witness that the format is question and answer, because this is necessary for our record. There are no narratives and there are no conversations with witnesses and between witnesses and lawyers. We just don't have that kind of discussion. It's question and answer. If the witness continues, one side may object to the testimony as non-responsive and move to have the answer stricken, either in whole or in part. And let me say, as a trial judge, and sometimes the lawyers are doing this too, I am constantly envisioning or in my head how the transcript of the case will appear. If someone says he, and it's not clear who he is, I'll ask the witness to identify the he. Clear questions and direct answers make for a great record or transcript. And part of it is afterwards, sometimes there may be other legal proceedings that take place, and we want to be sure that the answer has given the answer that will make it clear to resolve the dispute. As I've already alluded, witnesses often complain during and after testifying that the lawyers don't understand the problem. And I'm sure that some of you more experienced witnesses have said that. They don't get it. And I'm going to tell you that if you want to give an explanation to everyone that will help everyone understand what the problem is, it's not wanted. All right? Don't volunteer. I know that many of you want to explain something, okay? And in as much as explaining something, not explaining something is counterintuitive, I again state that this is not about you or what you know. And a friend of mine who's a retired academician said, you know what? The academicians are the worst. And because they want to show their body of knowledge. We don't want that, okay? Lawyers don't want it. They frown on it. They've got their narrative, and that's what they want to put in front of the trier of fact, the judge or the jury. So don't worry about it, because if you do, you may be opening a can of worms that no one is interested in hearing about, all right? And there are other down parts about that, but I just want you to understand that. Okay. So we're about 40 minutes in. So when you answer, you must answer out loud and use an English word. This may be obvious, but the record is generally kept through a court reporter or by a recording. In our daily speech, we use visual gestures such as the thumbs up, the nod, or the uh-huh to indicate agreement or affirmation. Physical gestures are difficult to record by the reporter and the recording device if they use one. So it's important that we have an accurate record of your verbal response. If there comes a time when you're not sure, don't guess. Speculation is of no value to creating a record. If you don't understand a question, you can say so. The lawyer may ask again. I may have the lawyer ask the question again, or I may ask the lawyer to ask another question, because frequently, if you're seeing that the lawyer doesn't understand what's going on, they're not going to be asking the kinds of questions that will get the answers that they want out of you. And many times lawyers are frankly unintelligible. Their questions you can't follow. I liken it to the cartoon where they do the wind up. They've got 3 or 4 or 5 conditions before they ask a question. And you are sitting there and you're saying, what do they want me to answer? So it's okay to say, I don't understand. Okay. And if you hear an objection, stop, because it means that I have to rule on the objection. That is, the court will. And the court will tell you if you have to answer, or I will tell the lawyer to ask another question. Okay. Sometimes you've heard lawyers ask the court to order a witness to answer the question. Your Honor, please I want to ask a request for you to order the witness to answer the question. I can think of only one occasion in 20 years on the bench where I ordered a witness to answer a question. It's I think lawyers have the ability to get and show that the witness is a poor witness, but it's also a poor reflection on you if you try to walk away or change the topic of the question. Okay, so the test of any witness, and you should know this, and I think this is important, is whether you have given credible or believable testimony. I've emphasized that because in deciding whether testimony is true and accurate, jurors, they really do, and the court use their common sense and life experience to evaluate you as a witness. A judge or a jury can consider anything in that box that reasonably tends to prove something or not. Okay, and there is no specific checklist of factors to weigh testimony, but listen to what judges tell a jury to consider when deciding whether you're a believable or credible witness. And I have a whole laundry list, but I'll just read three of them. How well could the witness see, hear, or otherwise perceive the things about which the witness testified? How well was the witness able to remember and describe what happened? What was the witness's behavior while testifying? Did the witness understand the questions and answer them directly? What was the witness's attitude about the case or about testifying? I mean, these are all kind of common sense things. We make these observations in our daily lives, so you need to be thinking about how you come across to the judge or jury. Okay. Most of you will be considered non-retained experts, which means that you are a fact witness who is a factor at a hearing or trial, and which would involve your expertise. The scope of your testimony as a fact witness is really limited to the information acquired while performing the work. In the case of a clinician, the testimony is based entirely on information acquired while treating the individual. All right. Let me turn to something else. Some of you have asked about working with the lawyer who has called you to testify before appearing in the courtroom. I expect that's your way of trying to get that lawyer on the same page as you. Treating physicians and clinicians as fact witnesses are viewed differently by the courts because you're viewed as a neutral witness acting in the best interests of the patient rather than as a retained expert or hired gun. So you're different, you're treated differently. Is there a best practice to prepare the lawyer who calls you? No, not really. We don't have that list, but when indicated and professionally appropriate, clinicians can certainly work with other professionals such as lawyers to serve clients and patients effectively and appropriately. These days, lawyers and courts have been focused on issues relating to the reliability and validity of your field of endeavor. And bear in mind, publications such as the American Psychiatric Principles of Medical Ethics and American Psychological Association's Ethical Principles of Psychology and Code of Conduct, which establish guidelines for clinical work and for ensuring that evidence offered in the forensic arena meets the standards of the profession. All right. And what we're concerned about is whether what you're doing meets relevant legal evidentiary standards and can withstand claims of junk science mumble jumble. All right. So to give you some idea here, I want you to think that your time is better spent on preparation. Know what you did in way of record review, understand what the individual's treatment history was in their family background. If you conducted an assessment, describe the methodology and procedures that were used. Did you forego a particular evaluation method or procedure? Was there a diagnostic interview? Was it face-to-face? How did the individual present during the interview? Did you administer a comprehensive questionnaire given to the subject or the patient? How long? What were the conditions? Was there recording, testing? Did you administer a clinical tool like an MMPI or the competency assessment instrument? Do you have training and understanding to appreciate the limitations of psychological testing? What about the issue of malingering? Okay, I was going to spend some time on LPS proceedings, but again, that might take a whole day. Be ready for the lawyer who's called you to ask whether there was work that you missed in your assessment, whether on direct or cross-examination. It's acceptable to concede weaknesses. In fact, you're viewed by the judge or the jury as forthcoming and therefore more credible. Now, I want to come back to saying too much, even if you believe it's important to offer true, accurate, and pertinent information beyond the call of a question. Additional material may not be necessary to a lawyer's case. You must be mindful that the lawyers ask questions with a narrative in mind, and opposing counsel may make an objection to strike your testimony from consideration from a jury. This can be embarrassing to you, and if it's frequent, the judge or jury might find your testimony less persuasive. And by the way, and I think university counsel would appreciate that, if you are a non-retained expert and you're subpoenaed by outside counsel, even for the most innocuous matter, please be sure to contact university counsel before you discuss anything with a third party, particularly if it's a lawyer or someone who's acting on behalf of lawyers. So make sure you talk to your supervisor or your university lawyer, see if there are any concerns. If there are none, then you can be sure that the lawyer will bring somebody like an investigator to sit with you during these questioning. This is a way of safeguarding the lawyer from having to testify. Okay, cross-examination. Once you've completed direct examination or made your presentation, opposing counsel will have the opportunity to cross-examine you. The obvious purpose of cross-examination is to challenge your testimony or your remarks in support of a petition or a complaint or or something that someone else wants. Something that very few people understand. And if this helps, you should know that absolutely nothing that the lawyers say during a hearing or a trial or any other proceeding is evidence. Okay? It's not, nothing the lawyers say is evidence. You are never told that. But jurors are told that in their opening statements or closing arguments, lawyers can discuss the case, but their remarks are not evidence. I told this to a surgeon the other day who's testified many times. He didn't know that. Okay, that's because no one told him that. But it's important because in terms of your old psyche about listening to lawyers, you're saying, well, gee, what they're saying to me is evidence, and it's not. Okay, only your witnesses, your answers as a witness are evidence. Lawyers can say things to suggest something else, but I told them something that is true. Don't assume something is true just because they're suggesting it's true. It's your answer that matters, not what the lawyer would have everyone believe. All right, let's get to the 4 areas of cross-examination. 1, they're going to attack you or they're going to challenge you on 4 different things. 1, this is where the things I talked to you about earlier, your record, your understanding what happened, is your knowledge of the facts. And typically, and just so you can get a feel for this, experienced lawyers typically start with getting you to agree on a series of facts, and then you get a yes or a no, and then you'll be conditioned to go along with the examiner, and then you reach a part where it may not be so clear, or you missed a fact that's not particularly critical to your testimony, but opposing counsel, you'll bet that the opposing counsel may exaggerate it when they're examining you, or they'll come back during argument and say, you know, he missed this, or she missed this, or they missed this. How incredible. Even though it's not particularly important, they'll use that to hang up the other side's case. Okay. You're not expected to know everything. Again, people every day understand that you're not going to remember everything. All right. 2. So the first one is a challenge to your facts, your knowledge. 2, your credentials. As a witness, opposing counsel may seek to show how your inexperience or training diminishes the weight of your testimony. It can be as simple as drawing a distinction between the populations that you serve. For example, you served as a clinician at a VA clinic in Fayetteville, North Carolina, and the clients you serve at citywide case management are totally different. It's just they're going to see if they're going to invite some examination about the way you've been trained. Maybe none of you are this, but maybe you went to a correspondence school or got a certificate. Maybe perfectly okay, but they're going to explore that. 3, so your credentials. So it's facts, credentials, your field of expertise. They're going to try and find anything you might say is bogus or bad or junk science. And 4th, anything that compromises your fairness, objectivity, and neutrality. The easy example would be a member of your family is the subject of your review. All right, so know your record, listen to the question, answer the question, and don't volunteer. Those are the basic rules. If you say anything more than what's necessary, you're giving the other side an opportunity to discredit you or cast doubt on your testimony. You can survive difficult examinations by being by being polite and firm. Okay. And let me summarize by remember that the confidence of a witness is rooted in preparation. Knowing your supporting records and what you've done is a must to support your case. All right, so let me also say being condescending, argumentative, hostile, or rude to counsel is as important as the content you are testifying about. So ignore what these lawyers may try to do. They can be abrupt, obnoxious, and so forth. You have to remain professional. Okay, last set of things, the role of the court and common objections. The role of the judge is to serve as a gatekeeper of the evidence that goes into that box. I have to make sure that the evidence that goes in there is reliable and valid use of that evidence. So you will hear common objections. I need to make sure that it's trustworthy. So common objections. All right. Some of you heard what's called the 352 objection. What's that? All that means is that the lawyer is saying, hey, that question consumes too much time, is likely to create a danger of undue prejudice, in short, inflaming the passion of the jury, confuses the issues, or is misleading. The underlying concern is that the evidence, whether or not it's testimony or tangible evidence, poses a serious risk to jeopardizing the fairness of the proceedings or the reliability of the outcome. 2, beyond the scope. You'll hear that sometimes. So that goes to the issue of explaining too much. It means that a witness is given testimony beyond the question asked. The objection is made when a witness volunteers information beyond what has been asked by the lawyer. And if you want to think about examinations, think about an ice cream cone. Each round of questions narrows the next set of questions. You can't go back and ask something new in the redirect examination that you should have asked in the beginning of the examination. Okay, so it's constantly narrowing. That's what trials do. We're narrowing the issues as we get down to the bottom line. 3, hearsay. Okay, hearsay is defined by the evidence code as an out-of-court statement made other than the witness that's offered to prove the truth of the matter. Okay, what does that mean? That means I tell jurors, it's a statement that's made outside the court where you, the jury, will not have the opportunity to understand or know what the conditions of the statement was made. So if the statement was made outside the box, which is in the courtroom, basically you don't get to consider what's outside the courtroom that was said because you don't get to see the circumstances under which the statement was made. Okay, so I think that, and once jurors hear that, they go, oh, okay, I get that. And finally, let's talk briefly about Sanchez. Sanchez is the same thing. What happened there was an expert witness, a gang task force case. The expert was testifying that so-and-so, Mr. Sanchez, was a member of the gang. There were charges about gang affiliation in the case. What that gang expert did was he testified about the field notes of police officers who identified Mr. Sanchez as someone who was wearing the gang colors and hanging out at the corner store with the gang members hang out and so on and so forth. Even though the expert did not personally observe any of this, he used those field notes to testify that that's what he saw, or that's what could be true for purposes of deciding whether Mr. Sanchez was a gang member. In other words, he was using the field notes and he was serving as a conduit for those field notes, even though everything seen, observed by the field officer was not testified to in the courtroom. Now, it's a different story. If it's in the courtroom, then there's a different situation, but that applies to experts. And I want to make this point because I think someone asked me, one of the psychiatric fellows asked me, well, what about, and I think you deal with this all the time. I talk to therapists, probation officers, social workers, family members, and I get the Sanchez objection. It's basically a hearsay objection. You can't use that material to specifically serve as a conduit for those individuals who aren't testifying in a hearing. Okay, so how do you get around that? Well, what the lawyers need to understand is that you can say you consider it, you just can't publish, you can't say in the court exactly what those witnesses said. You can say, I talked to these folks and this is the conclusions that I formulated. That's the Sanchez, I won't call it an exception, but that's what the Sanchez decision allows you to do. Okay, so I'm sorry, but I only have a minute to take questions, but I'm happy to speak to any one of you about questions you might have. I know there's been a lot of information to digest, and you know, it takes 3 years of law school to understand some of it, so I don't fault you, but relax, you got it. Just know that you're testifying about what you know, and the lawyer should be able to ask the right questions in order for you to be a true and credible witness. Thank you. If you want to remain afterwards, I'm here all day, so happy to talk to you.
Thank you very much.
Okay. I hope that was helpful.